Great. Well, welcome everybody to the Compliance Report. My name is Brian Feeley. I am the Senior Vice President of Marketing here at Corporate Synergies. And I'm really happy to welcome our two guests here, our two subject matter experts. Of course, what would a compliance report be without Dan Kuperstein, who is our ERISA attorney. He is our Senior Vice President of Compliance. And in addition, we have a special guest with us today, Pam Smith, who is our Vice President of Account Management. And as it relates to all the things that are happening with our clients, with employers, and what they are seeing, we're really excited to hear from her on some of the things that we're going to be covering today, which include, as you can imagine, we're at that stage now, hopefully coming out of the pandemic, and everyone's talking about, return to the office and vaccine mandates, incentives as it relates to that. Certainly the return to the work policies that people are putting together and implementing. But what are their impact on health and wellness plans? We want to make sure that we're covering that and hearing what's happening in the field. So we want to make sure that we cover those areas and talk to our experts here to give us a little bit more guidance. You may be asking yourself, what is it that I need to do if I want a vaccination policy? Can I require it? Are there regulatory issues? Can I use wellness incentive dollars to be able to incentivize vaccines? What are all of those things that are circling around in our heads? Let's try to clear it up for you, provide some clarity. Dan, we'll start with you. Why don't you give us a sense of some of the recent developments that have taken place that are really driving some of the questions we're hearing?
Yeah, sure. So at the end of May of this year, the EEOC released a long-awaited update to its technical assistance guidance on COVID-19 and the Americans with Disabilities Act, or ADA, and other federal equal employment opportunity laws. And the document addresses how employers can stay in compliance with these laws when either requiring or incentivizing COVID-19 vaccines. And the updated EEOC guidance really, the big news from it really is that it allows employers to require or incentivize vaccination before returning to work, but it also requires employers to make reasonable accommodations available for employees with disabilities, individuals with sincerely held religious beliefs, and pregnant employees, unless granting such accommodations would create what's called an undue hardship on the employer's operations.
So give me an example then of some of what we call reasonable accommodations.
Sure. So some examples include for unvaccinated employees, for modified work schedules, telework, or reassignment to a vacant position. And obviously, that these types of things are really going to depend on your organization's specific, operational requirements and things like that, because of that undue hardship exception.
Well, so if I'm an employer and I'm looking to require vaccinations from employers before returning to the workplace, you mentioned accommodations. What are some of the specifics as it relates to what's required? So what are the common accommodations? You spoke to a little bit, but in addition to that, what's going to work for them in terms of, what truly is an accommodation, what's not going to work? How does that play into everything that the employers are looking to do with this whole vaccination and return to work?
Yeah, and I think really, typically, I think in most situations, and I'm pretty sure I'm speaking for Pam here as well, right? What most people want, most employees want, is really to be able to work from home, and that's really a common accommodation request. And if you remember, obviously pre-COVID, of course, that was really considered to be like a very special benefit or a special perk of a particular job. If you could, do that job from home, that was golden, right? That was flexibility. And the problem is, I think though, for most people, for most employees, right, is that not everything is going to be considered to rise to the level of a disability or a sincerely held religious belief that would be sufficient for the employer to grant the accommodation. So, for example, just because an employee believes in conspiracy theories or other misinformation they got online, right, that doesn't make that a sincerely held religious belief under the law. And similarly, generalized beliefs about potential risks to a spouse's health from an employee going to work, those types of things, those aren't sufficient to rise to the level of a disability. And then additionally, employers have an exception that I just mentioned kind of briefly before, which is, the accommodation that's granted cannot create an undue hardship on the organization. And that's going to be something that the EEOC really seems to evaluate on a case-by-case basis, depending on the type of accommodation requested and your specific organization's industry and operations.
Okay, so let's take it from the point of a request. Imagine that an employee makes that request for an accommodation. What are the steps needed to be conducted by the employer? What do they have to initially do?
Right. So the first thing you start out with doing is what's called the interactive process. So it's a very specific process that is outlined in the new EEOC guidance, and it typically includes asking questions or engaging with that employee to try to determine, right, what is the particular accommodation that's needed for the disability, and that can include requesting medical documentation from the employee's healthcare provider with the employee's consent, of course, and explaining why an accommodation is needed. So, so you have to engage in this interactive process according to the EEOC, and that's a big first step. That's like really the prerequisite.
So outside of taking that first step and going down the path of realizing whether or not it's a true accommodation that should be granted or not, you also have a large population that's still, for those that are looking to require vaccinations, they're unvaccinated and they're saying, hey, can we use incentives? I know that, for instance, you're hearing a lot in the news about municipalities and counties and states. They're doing lotteries, they're giving away cars, they're doing all kinds of things. So I think it's important to understand where that line is as it relates to incentives. So why don't we go to Pam, because I know you're dealing with this a lot. And Pam, the question of incentives, is there a maximum incentive allowed? How do you get started to really understand vaccinations and the incentives that clients may be thinking about right now?
Sure, Brian. So let's start with the question about the maximums. The EEOC guidance never gave us a specific dollar amount. It says that offering incentives to encourage employees to receive a vaccine administered by an employer or an agent is okay, as long as the incentive is not so substantial as to be coercive. However, coercive wasn't defined precisely, so we really don't know what that amount is. What we're finding is that most of our employers are offering incentives that are under $200. And since that, as far as we know, no one's being sued by the EEOC yet for an incentive under $200. It's probably okay to offer that type of incentive. Although one of the larger issues that I've seen is that employers want to use wellness funds to pay for the vaccine incentives. Especially some employers have a larger reserve fund. They haven't been doing the wellness programs that they had used to do prior to the pandemic. But because of the regulatory uncertainty surrounding wellness incentives, we generally recommend to employers to play on the safe side and run that incentive program outside of the wellness plan.
Yeah.
Is that, Dan, you mentioned earlier as well, Pam, that not all the guidelines have been released. Is that part of it?
Yes, definitely. So as of now, the EEOC is still reviewing wellness incentive regulations that were issued during the Trump administration that provided that wellness plans subject to the ADA and GINA cannot provide wellness incentives that are more than de minimis, and that's generally been interpreted to mean no more than a value of something very small, like a pencil or a water bottle. And so even though those regulations are technically under review right now, which means that they're essentially frozen until the EEOC under this administration can review them, the conservative approach would be to not run that COVID-19 vaccination program through a wellness program, as a wellness incentive done through the wellness plan may be deemed to be more than de minimis, and that could mean that it violates the ADA and GINA, especially if we find that the new EEOC agrees with the old EEOC, which could certainly be the case. And so that's the conservative approach, and that's generally what we've been recommending. And
better safe than sorry, right?
Exactly, better safe than sorry. And I think that's how most employers want to do it. Why risk it, right? And of course, since we're discussing a future development here that we're on the lookout for, I think that's a good time to put out a quick plug here for our these soon to come, for our updates on these soon to come changes, which we keep on our Compliance Resource Center page, Heather posted to the chat. So definitely recommend you check that out and monitor that. We'll be putting our comments on that as things develop there.
So we're going to be putting out more e-alerts, it sounds like, Dan.
Definitely. There's a lot more of those coming out.
What about, can you tell us a little bit more about the incentives as it relates to family members? And you're hearing more about this in the news. Just recently, they're talking about the ages, children vaccinations, but think about family members and where does that line get drawn as it relates to this idea of incentives?
Yes. So, the question of like, well, can you do it, right? I mean, the answer is yes, you can do it, right? You can offer an incentive to an employee that shows, right, documentation that they got a family member vaccinated. But if you're going to do that, right, you really have to be very careful about how you do it. And you don't want to do it if your organization is offering the vaccinations on site, that is through the employer or through one of the employer's agents, or an employer's employee is kind of running everything, as that could run the risk of violating GINA. So that's one of the things talked about in this new guide.
We don't want to upset GINA at all.
Don't upset GINA.
So actually on that, and you mentioned all these different rules and being safe, and sorry, but maybe if you can give us some examples of where those lines are so that employers know, where they should be very careful. Why is it that they need to be so careful on this? What can they do? What they shouldn't do? What can you get into that a little bit for us?
Yeah, definitely. So GINA is a law that protects employees' genetic information that the EEOC enforces. So it's an important law. And generally the way it works is that it prohibits employers from requesting certain family medical history information, which is, comes into that broad definition of genetic information under this law. And so specifically here, right, the EEOC guidance is clarifying that employers can offer incentives to employees who provide documentation that they and their family members received a vaccination, if it's from an unaffiliated third party, like an unaffiliated vendor or the government or something like that. But if the family members are involved, then the employer cannot offer an incentive if the employer is running that vaccination program through the employer or the employer's agent, as that would violate those provisions of GINA that prohibit employers from requesting the family medical history information from the employee. So the bottom line here is, that's a lot of legalese there, and I hope I didn't put everybody to sleep, but bottom line, right, is that it's easier to comply with GINA if you're using an unaffiliated third party to administer the vaccines, whether that's, letting the government do it or just hiring, an unaffiliated third party vendor.
So when hiring a third party or hiring anybody, you're hearing more about these on-site vaccination programs. As it relates to being on site, are there additional compliance risks that an employer needs to be aware of?
Yeah, and that's a really great question, because I think we're seeing more and more of it happening on site now. And in addition to GINA, providing it on site can make it then more difficult to provide employees with a level of confidentiality that's required under the ADA and HIPAA. And there are some strict requirements there. Generally speaking, there needs to be a sufficiently strong level of separation between, on the one hand, your organization's HR and personnel practices and procedures, and then those are like the laws typically enforced by the EEOC. And then on the other hand, your organization's medical plan, administrative procedures, laws subject to HIPAA, things like that. So that's one of the things that I think is one of the things that a lot of employers, especially the smaller employers, are having some difficulty with.
What about the capturing of information as it relates to all of this, the records themselves? Is there any requirements surrounding that?
Yes, and to the extent that any of these vaccination records are held or retained by the employer, right? The EEOC guidance provides that in order to ensure compliance with the ADA, all of those records need to be kept strictly confidential, treated like a medical record, and kept in a separate file from the employee's general personnel file. So pretty strict requirements there. That's why I always say it's easier just not to do it on site if you can avoid it. It's just a lot of hurdles. It's better just to say, hey, let the government do it. Employee shows some documentation or attest to it. That's the best, easiest way to do it, at least from a compliance standpoint.
So Pam, I'm curious. Are you seeing any of this in the field as well? regarding these types of questions. And I know that in addition to the things that Dan was talking about, I know they've talked about using wellness dollars, wellness incentives that have been unused, let's say. But there's other forms of potential incentives, paid leave, sick time, and things of that nature. Is that the kind of questions that you're seeing in the field?
Well, I haven't yet seen any employer offer incentives for family members getting vaccinated. We have certainly seen questions about incentivizing employees. Mainly those are sticking to that under $200 amount and not a vaccine on site. So, while we have seen vendors offering to bring vaccines on site, really the majority of our clients are opting for off-site vaccines. Certainly, they're educating their employees on how to connect with with a third party to get a vaccine. But really, with no cost to the employee and the family members to get vaccinated, and the fact that for the most part vaccines are widely available. Third parties are being used for the actual vaccinations, and then employees would provide proof for any possible incentives.
Speaking of which, on the incentives, I want to go back, and this is kind of for both of you, if you know the answer to this. So imagine that you're doing an incentive and it's under $200, and you're doing it with all the staying within the guidelines that have been spoken about already today. Is it taxable? Do you know?
Yes, so I can answer that one. So unless it's something like you're just if you're just reducing something that's not taxable, like reducing a premium or something, like, there's obviously probably no tax impact to that if it's, through a wellness plan under certain circumstances, but generally speaking, yes. So, that could be a big hit, obviously, for somebody who, especially if you're doing that, all paid Mediterranean cruise or whatever it is that they're going to win, right? As part of your incentive program, you really want to be thinking kind of about the fact that it is taxable. And that could have a big hit on an employee. So definitely something to consider.
I think there's actually also one other thing that we should mention too, is that there has to be a reasonable accommodation with the incentives as well. Correct, Dan?
Yeah, so I think it's important to mention that. I mean, I think so we don't miss that part of it. That's a really important part relevant to incentives that, that is often overlooked in all of the discussion, right? Is that even if you are offering just incentives, which can make a lot of those tough decisions easier decisions, right? Because it's not a mandate, right? But even in incentive programs, you still need to make sure that you're giving the employees the same opportunities to request accommodations on those same bases that you had before. Additionally, in the incentive program, there should be a suitable or reasonable alternative standard or method, right, that the employees can choose to get that reward or incentive without actually getting vaccinated. So that allows people, for example, who can't get vaccinated, whether it's because of a disability or whatever it is, to still get that reward. So that's an important component that's absolutely necessary.
All right, shifting gears just a second, because we want to make sure we cover some of the things that are definitely in the headlines. And I know that a lot of employers are thinking about this, as there is a lot of folks that, in addition to just working more remote, working virtually, you're seeing in many cases almost an exodus to different states, people moving from state to state, getting that plot of land out in South Dakota that they always wanted, and now being able to work. But in doing things like that, as you see the changes happening in the workplace and geography, how does that impact your health and welfare plans? And what are you dealing with as it relates to that, Pam?
Yeah, that's a big question, especially so relevant right now as employers are planning for reopenings and realizing that some employees have now moved out of state. So it's really, it falls back into the bucket about questions about workplace accommodations that we were talking about earlier in the session. And what I mean by that is some employees' living situations have changed dramatically over the time that many of our clients' workforces were remote, and as the offices are opening back up, there are a lot of questions about employees moving to different states and the continuation of remote working, and how that impacts the employer in terms of benefits, but specifically in terms of statutory benefits. As employees may have moved to different states that have other statutory benefits that employers have to consider.
But state leave laws and regulations state to state, they're pretty common and consistent state to state, are they not, Pam?
State leave laws.
Clearly they're not.
No, and Dan knows well that certainly as employers are assessing how they want to open back up and what accommodations they're going to make for employees, really on an individual basis. These things need to be evaluated, and I'll give you, I guess, a couple of examples. An employee moving out of state that's not commutable to an office, might be a situation that we're kind of talking about, out of state, regulations, and some states are regulated much more strongly than others, and that might impact the workload or even financially your organization. So and then there's also employees that didn't move at all, but they live outside of the state that they might be commuting across state lines on a daily basis, or did prior to the pandemic, and maybe requesting an accommodation. And there really, it's also important to understand that if they are not working in the state, they may or may not be eligible for those statutory state benefits that they had before. So as far as questions that we're getting is how is that impacted? Where are the lines? What how much time does an employee have to commute into the office to be considered working at that location? And how does it impact their benefits as an employee? Because as you're considering the accommodation from an employer perspective, you also need to make sure that the employee understands how their benefits may have changed.
Dan, I can imagine that brings you into a lot of conversations and meetings as it relates to those kinds of guidelines state to state.
100%. And I think that, those examples that Pam gave are really great examples, because that's exactly what we're seeing. And there's so many different, I loved your softball question earlier, because there's so many, it's so different in every state that it's something that really needs to be looked at in advance. And even though we're not, obviously, Pam and I are not experts in labor law, we have a very good understanding of what those state benefits laws are. And we definitely can feel free to come to us before you talk to your, attorney or something like that to get our perspective. But the real thing here is, right, you want to be making sure you're doing this in advance, right? I think the key takeaway from kind of our discussion from before and that we're having now is that as an organization, you want to look at what could be an undue hardship for us, right? What are those things that, if an employee were to move to somewhere like San Francisco or, the other corner of the country, is that going to be an undue hardship, right? And then you want to make sure you're documenting that in advance of having these things happen. It almost never happens, right, in reality. But the reason for that is because, you don't want to have to do it later after the fact, right? Because it's harder to prove that it's not because of discrimination that you're not letting somebody go, right? Or letting somebody take the accommodation they want, right? And it's also really just important just from the standpoint of just, understanding, looking at all this stuff in advance, because you never really know how it's going to impact your operations when that person just goes, right? If they just leave, they're up and out to their other state, and you don't really know what impact that's going to have on your operation until after the fact sometimes. So I think for some takeaways here, right? It's really important to look at the different statutes and ordinances in each of these states, and they often have very different requirements, and some may or may not be what's called extraterritorial, right? Meaning that, even if your organization doesn't have an office in that state, right, that state is going to impose its laws on you as an organization, and you have to comply. And so that's a big problem. And also, what is the impact going to be on the employee? Maybe the employee is requesting the accommodation, and wants that accommodation, but doesn't even have a full understanding of the implications. And like Pam said, because of the statutes and ordinances in that new state, is going to have much less state benefits. And so all of those things are just super important to be doing, and to be doing in advance. And that's certainly something that we can help your organization with.
So it sounds like a lot of homework on the part of the employer to make sure that they're up on HIPAA, GINA, ADA, understand state law, work with their broker, and for our clients, working with teams such as Pam's team, working with our compliance folks to make sure that they're guided in the right direction. So many decisions to make, but I think this was very helpful. We had a few areas that seem like they're going to change. Maybe some more guidelines that will be coming out, some more information to follow. E-alerts, will be sending those out. But Dan, what's next? What can people look forward to? I know we have some other things lined up for folks in the future. Maybe you could talk to that a little bit.
Yeah, well, definitely. Even before I talk about that, I think we should. We're watching very closely what's going to happen with the American Families Plan, which could create a federal paid leave program. Obviously. I don't think that's happening anytime soon, but obviously that could alleviate some of these state-to-state different benefits and insurance issues and complications. But in any event, you should be staying tuned to our compliance resource page that we talked about before. But also on September 14th, we're going to have our next quarterly compliance review webinar. So we'll be talking about all of the many different things that have happened between now and then. And then also, I would definitely encourage you to check out our HAWC, spelled HAWC, LinkedIn group, which is a place where you can get a copy. You can actually get the recording for this briefing and stay up to date with our other benefits compliance developments.
That's great. Dan, Pam, thank you so much. I want to say thank you to all of those who came out to listen to us in this live briefing today. We really appreciate it. Stay tuned. We'll be in touch with you for more briefings and webinars and other resources that you'll be able to take advantage of. Take care, everybody.
Thank you.
Great. Thank you.